If you're going to be testifying in court, whether it's for a criminal case, a restraining order, or anything else, this video is your survival guide. I'm going to walk you through the 10 most common mistakes that people make during cross-examination. That is when the enemy lawyer gets to ask you questions. I'll show you the mistake, and then I'll show you what you should do to get it right and not allow them to gain any points while you are on the witness stand. My name is Veronica. I'm a domestic violence defense attorney, and I help people throughout the entire state of California put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself at a restraining order hearing and win. So if that is something that you're dealing with in addition to a criminal case, make sure to get your free class down below. Okay, so let's jump right in. These are the 10 cross-examination mistakes that can kill your case, and make sure to stay till the end because even one of these can be enough to make the judge or jury stop believing you. Mistake number 1, saying I don't recall when you definitely should. Saying I don't recall is totally fine when it's true, but when you use it on something major, something that you should remember either happening or deny happened, it can destroy your entire case. So let me show you what I mean. Isn't it true that on May 19, 2024, you severely beat the petitioner? I don't recall. Oof. What do you mean you don't recall whether or not you committed a felony assault? That's not a small detail. Look, that answer implies that maybe it happened so many times that you can't keep them straight. Now, maybe it's unintentional. And maybe when saying, I don't recall, the witness means that they don't recall what happened on that day. But if something serious did not happen, you should and you must be able to say that clearly. So let's fix it. Absolutely not. That never happened. Clean, confident. You shut it down. That is how you survive a question like that. Mistake number 2, agreeing to absolutes like always or never. For those standardized test tips, we say, watch out for always and never because they're usually traps. The same idea applies here. If you say that you never did something, all the other attorney has to do is show one example where you did it and your whole credibility falls apart. Watch what happens here. You never yelled at the petitioner? Never. I'm showing you what's been marked as petitioner's Exhibit A. This is you yelling at her outside of her apartment, isn't it? That's it. You're impeached, meaning the lawyer has shown that you said something that was not true, or at least something different than you said before. You look like a liar, even if you weren't trying to lie. Here's how you avoid it. Not to my recollection, no. Now, even if the lawyer does have some piece of evidence that they want to show, you've left enough room that you're not locked into a statement, and now they're not going to be able to show that evidence. Mistake number 3, volunteering information. A lot of witnesses think that they are helping by offering more or that they sound more credible, but all that they are doing is giving the opposing attorney more material to cross them, meaning question them on. Let's see it. Did you send the petitioner a message on June 3rd, 2024? Yes, but I only did it because she texted me first and I was trying to keep the peace and co-parent and the question was, did you send a message? That's it. All that extra stuff, that is now cross-examination material. Now, watch how to do it right. Yes, simple. Calm. You answered the question and kept control. Mistake number 4, getting riled up. This one is big, especially in domestic violence or relationship-based cases. If you show anger on the stand, the judge or the jury will start imagining that same anger in the moment that you are accused of wrongdoing. Lawyers will try to provoke you. Watch this. You stalked the petitioner, didn't you? That's a lie. She was stalking me. You don't even know what you're talking about. Even if everything you just said is true, you just lost the credibility war. Now watch how a calm witness answers. No, that's not true. No drama, no outburst, just control. That's what makes you look like the trustworthy one. Mistake number 5, walking into an impeachment trap. There's a very specific setup that cross-examiners, so the enemy lawyer, will use when they are about to try to bring in evidence that contradicts your testimony. It starts like this. You said XYZ. Are you sure? Are you absolutely sure? Are you 100% certain? Let me show you why that's a red flag and why that is dangerous. You said you broke up with her. Are you absolutely sure? 100%. Let me show you this text where she breaks up with you. Boom. Impeached. And now the jury thinks that you lied even if you just misremembered. Try this instead. To the best of my recollection, yes, but there were a few back and forths. That language. To the best of my recollection, that's your shield. You did not overcommit. You left space for human memory, and now that enemy lawyer is not going to be able to show that evidence. Mistake number 6, authenticating documents. Lawyers need to lay foundation to get documents into evidence. If you say that a document looks real or accurate, they can use it. Don't make it easy for them. It's possible that they may not have another witness or another way to get that evidence in. So let me show you what I mean. Do you recognize this screenshot? Yeah, it's a text I sent her. That's all it takes. That document just made it in. Let's shut that down. I haven't seen this screenshot before. Isn't it true that this is a text that you sent to my client? I'd have to compare it to my own messages to confirm whether it's accurate. Now the enemy lawyer has no foundation. You've blocked them from using it unless they have someone else or some other way to get it in, which again, they may not have. Mistake number 7, trying to win during cross-examination. Cross-examination is not where you win your case. Your goal is keep it short and survive. Remember, during cross-examination, you have already given your side of the story first. After cross-examination, if there's something that your lawyer believes needs to be cleared up, you will get a chance to clear that up. It's called redirect. Watch what happens here. You called her 5 times on the evening of March 5th. Yes, but I was just trying to talk things out. I wasn't angry. I just wanted her to understand what really happened. And I thought that if we could just... Nope. That answer sounds like you're trying to spin the situation. That doesn't build credibility. It erodes it. Here's how you handle it instead. Yes, that's it. No explanation, no attempt at damage control, just the truth. And if that fact needs context, your lawyer will bring it out later. Your job in cross is to get through it without lighting yourself on fire. Mistake number 8, guessing. If you do not know the answer to something, then say so. Guessing during cross-examination is dangerous. You might think you're being helpful or you're sounding knowledgeable, but really you were just opening the door to contradiction. Once you're wrong, you look like a liar, even if you were just trying to be helpful and cooperate. Let's look at an example. You got home around 9 p.m. that night, right? It was 9 p.m. Same time I get home every night. I'm showing you what's been marked as Petitioner's Exhibit B. This is you walking into the building at 11:42 p.m., isn't it? That's what happens when you guess. You gave them an opportunity to destroy your credibility over a detail that didn't even matter. Here's the better way to answer when you're not totally sure. I'm not sure of the exact time, but I got home later that evening. That answer is safe, honest. It shows that you're not trying to fake confidence about a fact you don't actually know. And they didn't get to play their video. Mistake number 9, not answering every part of the question. Sometimes lawyers ask compound questions that actually contain 2 or more facts or 2 or more questions. Now, if you have a lawyer, if you're not representing yourself, your lawyer should be objecting to this and say objection compounds. But if they are not on top of their game, or if you are representing yourself, you need to make sure that you answer every part of it, because if you only respond to one part, the judge might assume that you agree with the rest. Let me show you. After she told you not to contact her, you called her 5 times that same night, didn't you? Yes, I called her. That might seem fine, but here's the problem. That answer sounds like you're agreeing to everything. That she told you not to contact her and that you called her 5 times. But what if she didn't tell you not to contact her? You just admitted to something that isn't true because you didn't answer carefully. Here's how to do it right. Well, I did call her 5 times, so that's a yes, but she never told me not to contact her. See the difference? You answered every part of the question clearly and accurately. If you're not sure whether the question has more than one part, ask yourself, what exactly am I being asked to admit here? Break it down. Or you can even tell the lawyer, I don't really understand the question. Can you rephrase it? Don't let the other attorney sneak in an assumption without you realizing it. Mistake number 10, trying to sound like a lawyer. People do this all the time in court when they're scared and when they have done their research like you are doing right now. They think that if they use formal, polished language, they'll sound smarter, more innocent, or more believable. But to the judge and to a jury, it usually sounds fake. Watch what happens here. Isn't it true that you raised your voice during the argument? I may have elevated my verbal tone in response to the petitioner's emotionally provocative conduct. Come on, nobody talks like that unless they're reading from a script or trying to win an Oscar for best imitation of a defense lawyer. Here's how a credible, honest person answers that question. Yes, I raised my voice. That's it. No fake lawyer words, no weird spin, just a human answer. Judges and juries don't want a performance. They want the truth. All right, so those are the 10 mistakes. Now, remember, cross-examination is not about performing. It's not even about winning your case. It is about not losing. Keep it short, keep it calm, keep it boring. I hope you found this video helpful. If you do have a criminal case in California that you need help with, feel free to book a consultation down below. You can also find my number there. And if you did find it helpful, please don't forget to like, subscribe, and ring the bell.